Mr. Park, would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
I've spent a lot of time studying your record. You're a bright young man. You're an activist, aren't you?
Senator, I don't think that's a fair description of my record.
Okay. You have a history of substituting your judgment for your client's interests. My impression of your record, and I've studied it carefully, is that when you think you're smarter and more virtuous than your client or the law, you substitute your own judgment.
What's up, Patriots? Welcome back to America First, the channel where we fight for truth, justice, and the American way. If you're new here, make sure you like this video, hit that subscribe button, and turn on notifications so you never miss the latest updates on how we're holding the left accountable. And if you're already part of the America First family, welcome back. Let's dive in. All right, folks, today we're talking about a recent Senate Judiciary Committee hearing where Senator John Kennedy absolutely destroyed a Biden judicial nominee, Mr. Park. Now, let me tell you, this hearing was an eye-opener. It exposes exactly what's wrong with the radical left and their agenda to infiltrate the judiciary with activists who put their own opinions above the law. This is not just about one man. This is about what's at stake for our country. The rule of law, the Constitution, and the very foundation of our republic. Let's break it down.
And that's a dangerous thing to do if you're a federal judge. It's a dangerous thing that you've done as a Solicitor General. Berger v. North Carolina, State Conference of the NAACP. The North Carolina legislature, elected by the people, passed a voter ID law. NAACP, as is its right, filed suit to challenge it. You were supposed to represent the people of North Carolina in the legislature. You dumped on the case, didn't you? You purposely tried to lose, didn't you?
Senator, not at all.
Well, your opponents, NAACP, filed a multitude of affidavits and expert opinions. You declined to offer a single expert witness affidavit, didn't you?
Well, Senator, let me clarify. I had no role in the trial proceedings. I'm an appellate lawyer.
Did you and your office decline to file any affidavits whatsoever?
I don't recall, Senator. I believe that is accurate, but again, I was not involved in the case at the time.
I checked. You didn't. The district court ruled for the NAACP. You didn't seek an injunction or a stay, did you?
I believe that's correct.
Yeah,
Yes.
I know it's
Yes.
correct. You dumped on the case.
Senator, I don't think that's a fair characterization of what happened.
I do, and I think the facts bear it out. So then you take it up on appeal. In fact, the leadership in the legislature, because you dumped on the case, they tried to intervene. Said, our lawyer is not representing us, for God's sakes. They tried to intervene, the judge said no. So the case goes up on appeal to the Fourth Circuit. The Fourth Circuit reverses the district court, even though you and your colleagues tried to lose the case, and you did. It goes up to the Court of Appeal. Court of Appeal and the Fourth Circuit rules in favor of the state. You're representing the state. You tried to appeal the decision that was in your client's favor, didn't you?
you mean the intervention dispute, Senator?
No, you tried to reverse the Fourth Circuit that ruled in your client's favor.
Senator, that is not accurate.
Yes, it is. Yes, it is. You filed a petition for an in-bank review to overrule the panel opinion.
Senator, that's actually inaccurate. That's the intervention dispute. My office, there were 2 parallel appeals, and on the merits of the appeal, which we did appeal the non-entry of a preliminary injunction, and we prevailed on that appeal, working with the legislative defendants in that case.
Okay. School funding case. You were supposed to, you and your colleagues were supposed to represent the state in that case. Low-income school districts, as happens in most states, sued the state to force the Republican legislature to increase their funding. You're supposed to represent the state. You and your clients dumped on your client. You and your colleagues dumped on your client again, didn't you?
Senator, as Solicitor General Brasher told this committee a few years ago, the Solicitor General does not make those decisions.
Right. This is what you and your boss said. And it's your boss's words, but I didn't see you objecting. He said, today, quote, I'm going to quote, today, lawyers from my office are arguing that we must invest more money in our public schools so our students can get sound, basic public education. Y'all dumped on your client. You did the same thing. You refused to represent the state of North Carolina in defending the law with respect to abortion, too, didn't you?
Senator, I had no role.
You knew nothing about it.
Well, I was aware of it happening, but
right.
Okay. Senator, the Attorney General.
Look, you're a smart young man. My esteemed chairman's going to cut me off, but you can't. I know you're smart, and I know you think you're more virtuous than other people. But that's a dangerous trait when you're a federal judge. I just don't think you're mature enough to be a federal judge. I don't think you'll follow the law. I think you'll try to bend the law to what you think is right. And that undermines our federal judiciary. And I don't think you've been candid with this committee. You know that, and I know that. And your record knows that.
Do you want to complete your answer to any of those questions?
Thank you, Chair Durbin. On the voter ID dispute, I think that's a helpful illustration. I had no role in the trial court proceedings. I don't even believe I was updated as the litigation in the trial court was happening. But when we had an adverse order, my role was to play a part in authorizing the appeal. I did authorize the appeal, and lawyers in my office prevailed in vacating the injunction against the voter ID law that had been entered by the district court. There was a side dispute on intervention as to whether the legislative leaders should have been allowed to intervene. I think 2 points there. We never opposed their right to intervene. I told the Supreme Court that in a brief that I signed, that we do not oppose their right to intervene. And we also said in a brief that I worked on and authored large parts of, I substantively defended the voter ID law. I explained that the voter ID law was compliant with Supreme Court precedent and that we were prepared to defend it below and that we would do so. And I remember drafting this part of the brief, extensive argumentation about why the voter ID law in North Carolina was constitutional.
Mr. Chairman, can I respond? Please?
Sure, go ahead. Take 30 seconds.
I will. Look, Counselor, those are pretty words, but I'm going to tell you something. I've studied your record. And if I hired you as a lawyer and you did to me what you did to your client, the people of North Carolina, I'd have brought you to the Bar Association. I'd have filed a complaint against you for violations of the Code of Ethics.
Right out of the gate, Senator Kennedy didn't pull any punches. He asked Mr. Park a simple question. Would you lie to this committee to get confirmed? And you know what, Patriots? Based on Mr. Park's record, it sure looks like the answer is yes. Here's the deal. Senator Kennedy went through Mr. Park's history with surgical precision, exposing case after case where this so-called lawyer betrayed the very people he was supposed to represent. And let's be clear, this isn't just incompetence. This is ideological activism. That's it right there, folks. Kennedy nailed it. Mr. Park has a pattern, a dangerous pattern, of thinking he knows better than the people he's supposed to represent or even the law itself. Let's start with the Berger versus North Carolina NAACP case, where the North Carolina legislature passed a voter ID law to protect election integrity. Now, the radical left hates voter ID because they want to make our elections as chaotic and unsecure as possible, but the people of North Carolina stood up and said, "Not on our watch." And what did Mr. Park do as Solicitor General? He sabotaged the case. That's right, he didn't call a single expert witness, didn't submit affidavits, and didn't even ask for an injunction to protect the law. You heard me. He was supposed to defend the people of North Carolina, but instead, he sided with the radical left to try to sink the case. Kennedy didn't hold back, folks, and neither should we. Park denies it, of course, but the facts don't lie. And here's the kicker. Even after the Fourth Circuit Court ruled in favor of the state, Mr. Park tried to overturn a decision that helped his client. Think about that for a second. Who does that? This is not someone who respects the law. This is someone who thinks they're smarter than the law, smarter than the Constitution, smarter than you and me. And that's exactly the kind of arrogance we've come to expect from Biden's nominees. But wait, patriots, it gets worse. Kennedy also called out Park for his handling of a school funding case. Low-income school districts sued the state, demanding more money. Now, let me be clear. I'm all for improving education, but this wasn't about helping kids. This was about attacking a Republican-led legislature and forcing them to spend taxpayer dollars in ways that go against the will of the people. Instead of defending the state, Mr. Park and his office sided with the plaintiffs. That's right, he abandoned his client again. Kennedy even quoted Park's boss bragging about how they were working to force more government spending. Folks, this is not how the rule of law works. Lawyers are supposed to represent their clients, not push their own political agendas. Oh, and let's not forget the abortion-related cases. When North Carolina's legislature passed laws to protect the unborn, where was Mr. Park? You guessed it, nowhere to be found. He didn't defend the state, didn't defend life, and didn't defend the will of the people. Patriots, this is why elections matter. This is why judicial appointments matter. The left wants to stack the courts with activists like Mr. Park who will bend the law to fit their radical agenda. That's why they hate judges like Clarence Thomas and Samuel Alito, judges who actually follow the Constitution. Senator Kennedy summed it up perfectly. Mr. Park is not ready to be a federal judge. He lacks maturity, objectivity, and respect for the law. And let me tell you, patriots, we cannot afford to have people like him on the bench. This is bigger than one man. This is about stopping the left's takeover of our judicial system. They want judges who will legislate from the bench, who will ignore the Constitution, and who will push their woke agenda no matter the cost. So what can we do? First, we need to keep fighting. Call your senators and demand that they vote no on nominees like Mr. Park. Second, we need to stay informed and hold our leaders accountable. And third, we need to keep spreading the truth. If you're tired of the left's lies and their attempts to destroy everything we hold dear, then join our fight. Hit that like button, share this video with your friends, and make sure you're subscribed to America First. Together, we can take back our country and protect the values that made America great. Thanks for watching, patriots. Stay strong, stay free, and stay proud. This is America First signing off. God bless you, and God bless the United States of America.